We now proceed further, and our last presenter in today and in the second session is Professor Lehte Roots. She is a member of our own academic family here in Tallinn University in the School of Governance, Law and Society. And she specializes on European Union law, and particularly in the areas of migration, asylum, citizenship, free movement, and equality law and policy within the European Union and in Estonia. And her topic seems very intriguing, interesting. Algorithms and law, do computers understand law? So please, Lehte, the floor is yours.
Thank you very much. It's not an easy task because we are at the end of the day and probably you are very tired, and English is not my mother tongue. So I have a speech written down and I'm using my notes for today. But yes, this topic is also intriguing to me, and I selected it because I used to work, before I became a lawyer, I was working in IT company and dealing with Microsoft products, and so from there became my interest in also in infotechnology and the way how programs are actually working. So I'm really happy that I was invited to this conference. I can explain here my thoughts about this, how algorithms and law can match together, and if artificial legal intelligence is just a matter of algorithms or it is something related also to the law or to the lawyers, and how we as lawyers see the future. So if we think about algorithms, they are defined as step-by-step procedures which are normally used to solve some kind of problems, or sometimes they are in the form of formulas. And in the computer science, they are employed to perform tasks, process data, or sometimes even they can make decisions. The rules of algorithms embody in their core properties and principles governing their construction and evaluation. And I will first explore two types of algorithmic regulation, the code-driven and the data-driven. But if we talk about the legal field, we should not also forget that in the legal field we need probably text-driven regulation, and this must also be then considered. So reevaluating how our modern positive law, which is normally text-based, because we consider law as a text which needs then to be interpreted, it defines us the force of law and also the legal effect, which is also crucial. So when we now start to talk about the algorithmic regulation and the rule of law, then again, we need to go back to this algorithmic regulation, which is known as standard setting or monitoring and behavioral modification of computational algorithms. But if we think about the law regulation, it is something different, isn't it? So here already becomes this kind of confusion, which kind of regulation actually we are talking about. If you talk to a lawyer about the regulation, then you will get one kind of response. If you talk about the regulation with an IT specialist, then you get a different response. So what I want to say basically is that we need to have a common understanding of words. Therefore, we need to, as lawyers also, we need to understand what actually the algorithms are doing. So what they can do, they can gather data to have a better monitoring possibility, to predict something, but also they can influence the behavior of this artificial intelligence, not our behavior. So these interferences are drawn from data analysis, which is known as machine learning, and thus from the data-driven regulation. So we talk about the data-driven regulation here. And in this sense, our human intervention actually is becoming illusionary because as decision makers often do not actually fully understand what are the reasons behind the proposed decision if it's done by the machine. And this fosters compliance with algorithms as they are frequently presented as outperforming human expertise. So about what is then this code-driven and data-driven regulation? So when we talk about the code-driven regulation, then we talk about something which relies on so-known EFTTT. Yeah, and this means if this, then that. This is how the machine works. And it's providing the fundamental logic for algorithmic decision systems. And this logic is actually deterministic, predictable, and comprises some simple or complex decision trees. Whoever defines this as a condition, for that it determines also the system output. And it's leaving the users without no discretion. So we are not dealing here with the traditional artificial intelligence, but the legal knowledge management, if we talk about the legal artificial intelligence. It attempts to stimulate legal judgments, and instead we are engaging with systems capable of making decisions that affect actually legal subjects. So therefore it makes, to combine the algorithms of machines with law, quite complex issue. These systems then are often referred to smart regulations, or they are sometimes called also like typographic law. If you have heard this kind of word, Google, look it up. And particularly this word is associated with blockchain technology. And here we also encounter a deterministic and self-executing system that is neither transparent nor easily interpretable. This is what also the previous presenters have acknowledged or said, that the problem with the machines is this problem of transparency. We don't really understand or know what is behind of that decision, or it's difficult to understand. Can you imagine that in 2023, it was revealed that large language models, such as GPT-4, that you probably also have tried or used, had developed to such an extent that they just not only passed the American law bar exam, but they achieved nearly 90% of accuracy. So very smart, isn't it? Ali can become a lawyer, according to the bar exam results. So the advantages that stem more from scale of these models than from fine-tuning for specific legal contexts. So this GPT-4 consistently outperforms smaller models of fine-tuned for legal tasks. But from the security standpoint, it is crucial to note that general model doesn't remember the activities and information of attorneys. So we have actually a problem with these algorithms. Do we expect now the machines to take over our legal work in the future? The aim of justice is actually to approach cases without bias, and I think we have also discussed here, or other presenters have discussed this bias-based decision making, and it's not only the problem of machines, but also people might be biased, so we cannot guarantee actually a result which is unbiased result. But with the machines, it is very probable that the result will be biased because it's based on big data, which they are fed into to make the decision. Yeah? So if they collect the big data, then the decision is made on the basis of the big data, and it's already biased because it is a statistical outcome. So if this EFTTT decision system in law, for example, allows us in a taxation office to delegate specific decisions to a system, like for example, it is checking conditions through the feeds from various databases, such like it's collecting the income and it's collecting your bank account data, real estate data, and other assets, and then it applies appropriate legal norms like income tax or corporate tax law to issue then a decision on your tax amount. So while such decision can be explained by referring to the decision trees which are implemented, because we can make these trees and insert them to the computer, whether this justifies then the outcome depends also how our legal norms are then translated into computer code. And legal norms which are expressed in human language are often, as we know, ambiguous and are open to interpretation. Otherwise, we wouldn't need courts, isn't it? If law would be so clear, we wouldn't need courts. So this EFTT enables administrative decision-making with the rule of law. And decisions based on code-driven regulation must be comprehensible to the entity which is responsible for the decision, and it is accountable for its legality. So under the rule of law, such decisions must also be understandable to those subjects to whom this decision is made for, and also justificable in terms of the legal norms that actually authorize to make this kind of decision. So administrative decisions which are made through the code-driven regulations should always be contestable on two grounds. The first system applied legal conditions that do not apply because it misinterpreted the facts. And the second point is that the system incorrectly interpreted the relevant legal norms. This means that even if this EFTT standard is applied, one should be able to appeal if the system application of the legal norm is incorrect in the specific case. So we need a system that is actually also competitive. So we can claim that this is not correct, and we should know why this is not correct. So data-driven regulation, which is informed by ALI is artificial legal intelligence, integrates data-driven legal tech with the code-driven decision systems. And this form of regulation uses data rather than expert legal insights, which is translated into a code. And this ALI, or this artificial legal intelligence, primarily relies on natural language processing, where algorithms are actually already trained on legal text using the techniques like reinforcement learning and other relevant arguments, which then detect this applicable case law, statutes, treaties, and maybe also doctrinal treaties, or are able to predict then future legal outcomes. And this ALI, this artificial legal intelligence, performance depends on choice of the training data. So in this context, we need to use the legal texts to train the ALI. And the labeling of the hypothesis space, which needs to then to be set into mathematical functions, connecting input to output data. And the chosen performance metric is needed, which basically is the percentage of output deemed correct by legal experts. So it's very complex system that actually we need to develop to use law in the field of algorithms. So these kind of choices which affect the output reliability and comprehensibility and contestability are typically made by policymakers or technology people, not by the lawyers. And these remain largely invisible to those who are actually impacted by the Ali-based decisions. Yeah. So every decision which involves trade-offs, such as speed versus accuracy, generalization versus specificity, accuracy versus interpretability, so you always need to make these kinds of choices to tell the algorithm how he should proceed or how it should proceed. And therefore, Ali systems pose interpretability challenges to us, and it is essential to distinguish then between this explainability and justification, because it's not the same thing. It's not that if we manage to explain how it works, it justifies its decision. It's not the same thing. So knowing how an algorithm has arrived to the conclusion does not automatically mean that the conclusion is in accordance with the law, or that it really follows the law. So Ali itself is built on simulation, and it aims to approximate expert conclusions which are based on available data, but does not understand actually the decision it makes. But when the judge is making a decision, the judge probably understands why it makes the decision and has a justification also why it makes this kind of decision. Because Ali relies on prior human expertise and probabilistic estimations, but should not be the final decision maker. That has been also highlighted here by other professors, that we cannot really give all our work to the computers. There needs a person also behind that who then evaluates this kind of decisions. So therefore, what I said is that the decisions are generating problems of the interpretability, so we do not know how they are interpreting the data. And therefore, it is important to note that output from an Ali system can be explained in three different levels. At the level of research design, so basically, we need to understand which choices have been made, which trade-offs has been given to this algorithm in the terms of reliability and generalizability. Second, at the level of generalized output, consisting of inferent rules that supposedly determine argumentational lines or court decisions. And third, the individual level of individual predictions, targeting a specific case based on algorithms which is trained on the basis of the previous case law. And as I explained already, explainability should not be mixed up with justification, because knowing how the algorithm came to the conclusion does not always imply that the conclusion is in accordance with the law. It is not automatic. And Ali is built on simulation, so it basically tries to come as close as possible to what experts would have concluded if they were asked. It does not understand the decision it makes or prepares, and it relies on previous human expertise and estimates the probability on the basis of the maximum available input data, but it cannot be the final decision maker. So when we talk, as I mentioned already before, about the law and regulation, to understand the algorithmic regulation, we must first clarify the term what regulation means. It has two distinct meanings, which are not mutually exclusive, and they operate in different levels and different analyses. So regulation can describe any attempt to influence the human behavior, whether it can be done through the law, through force, it can be also done through manipulation. And this is known also as an external perspective of law, as it is focusing on the behavior rather than action and information instead of the meaning. Regulation can also refer to policy rules enacted by the administrative bodies, which is endowed with the regulatory or decisional powers by the legislator. And in this sense, a regulation is an administrative body. For example, in the context of data protection, US Federal Trade Commission is often referred as a regulator. In EU data protection authorities, European data protection and supervisor are also considered regulators. So the distinction between legislating and regulating is based on internal law. The binding force of such policy rules may be indirect, based on trust and legal certainty, or direct, where the legislator has delegated regulatory authority to the governmental agency, for example. So it is essential for lawyers to understand external perspectives on law, but equally crucial to maintain focus on the internal perspective, which is connected to the constitutional protections and checks and balances of the rule of law. So lawyers should also remember that grammar of law is based on the concept of legal effect, an internal perspective, which differs from the enforcement or social consensus, an external perspective. So law is just one way of regulating the society. From the rule of law standpoint, legal regulation is a subset of laws governed by the principle of legality. Law does not merely modify behavior, but coordinates, prohibits, and enables actions in ways that respect individuals subject to the law, recognizing the capacity to give reasons for their actions and their autonomy. The force or power of law depends on the attribution of legal effect when specified legal conditions are met. So legal effect creates institutional facts, but it is not simply a matter of causality. And institutional legal facts stem then from performative nature of speech acts and legal texts. So these facts establish also ownership, contracts, and human rights. In this sense, modern positive law is text-based, and it is known as text-driven law. And modern law is a set of rules, principles that constitute positive law, determining what counts as a violation of a legal norm or a right. These rules and principles derive from a binding source of law, legislation, case law, and treaties, and also we need to take into account doctrines, fundamental principles, and customary law. Courts and legislators produce these binding sources and are further implemented by the authorities. So we have to take into account also our constitutional democracies, that the interpretation of law is part of it and should be always challenged, or can be always challenged. When we give the machines the right to make these kinds of decisions, it might be difficult to challenge the outcome of those machines. So when we are regulating algorithms, we have to take into account our rule of law principles and the uncertainty of it. Because modern positive law, which is text-based or text-driven, defines what is lawful or what is unlawful by attributing legal effect when certain conditions are met. So this text-driven law creates also predictability by requiring authorities to provide reasons grounded in applicable legal norms, making government actions and decisions explainable and contestable. When code-driven and data-driven regulation is used, we must consider whether they simply form cybernetic regulation requiring the compliance with legality principles, or if we are dealing with code-driven and data-driven law. Double interpretation problem. So, how to translate legal text into machine-readable data? How to design decisions in problem framing, predicting case law, teach principles of law. I think there is a need of new methodology, a machine-understandable legal vocabulary that we lawyers must create and teach the machines to understand that. In the final part of this discussion or my presentation, I propose one method for bringing data-driven regulation under the rule of law by reinstating the adversarial core of the rule of law in data-driven decision-making. So what Ali okay, no, it should be that one. What Ali can predict and simulate legal decisions, and when combined with code-driven regulation, it can make decisions based on these simulations. This is what he has been taught to do. And Ali's credibility depends on several design choices that affect its validity, reliability, and stability. And these choices include the selection of performance metrics, which determine the predictive accuracy, the choice of training data, and the development of the hypothesis space, all of which is set boundaries by the mathematical optimization. Ali also presents a dual interpretative challenge. First, the legal text must be selected, translated into the machine-readable data. Who does that? Lawyers? Or the process requires labeling and need to remove irrelevant information, an action that involves also already interpretation. Who does that? Lawyers. Second, each design decision frames the problem to be solved, such as predicting case law, which also implies interpretation as it generates machine-based interpretation. So therefore, I say that new methodology and theory, which vocabulary is understandable not just for us as lawyers, but also to the machines, is really needed and is the future thing we need to work on. So coming to my concluding remarks, I want to say that the regulation of algorithms is a concept which derives from cybernetic or regulatory theory. And it is utilizing feedback mechanism which is based on requirements of standard setting, monitoring, and behavior modification. This is built on behaviorist perspective on human relationships, offering an external viewpoint on human action. So in my presentation, I have differentiated between code-driven algorithmic regulation, which is based on deterministic self-executing code, and data-driven algorithmic regulation, which is basically relying on machine learning and statistical interferences. That might be very unpredictable. It depends which kind of data it is analyzing, yeah? Or it gets. And this raises us the question, if law is a matter of regulation in the cybernetic sense at all, and if it is, whether this algorithmic regulation could replace or support legal regulation. I doubt, but let's see what the future brings. We can, however, analyze through regulatory theory the case, and law meaning is tied to specific understanding of human action and interaction. And lastly, I would like to introduce you Ali, which is the artificial legal intelligence. It was created by ChatGPT in seconds, because I asked him to do that. And so, welcome Ali, because I wanted to talk to someone. As a person, I would like to talk to someone, not just to type in ChatGPT. So I created, or I didn't create, ChatGPT created the Ali, and I asked this same question that I was researching for many days, from Ali. And in seconds, he responded to me, or it responded to me, that computers and AI do not understand the law in the way humans do. Instead, they can be programmed to process legal information, analyze patterns, and apply predefined rules or algorithms to the legal text. Maybe we should leave him to do that. Thank you very much.